Today we are going to be breaking down some new immigration news and updates and talking about what it means for you in your immigration journey, what it means for a family member in their immigration journey. I am U.S. immigration attorney Lilian Chukwurah, and I help my clients get green cards and citizenship for themselves and their families using the U.S. immigration law system. So let's start with the most recent thing that happened, and probably the one thing that's been in the news. Most of the time, immigration changes do not show up in the news. However, this was a recent executive action by the current president. So we have to talk about it, what it means, because it does have significant impact on people's ability to apply for asylum. So basically, with the new executive order, it breaks down this way. If the people entering the border exceeds 2,500, so 2,500, given day, right? So they're looking at 7-day period. It is more than 2,500 people that are coming in, and this is unauthorized, right? If you have parole, if you have a visa, that's not included. This is for people that are entering without any sort of authorization from the U.S. government allowing them to come into the U.S. If the number exceeds 2,500 in a 7-day period, the border closes, meaning no one gets in, right? No one gets processed. There's no asylum. And if you enter, after that, you will be limited on your ability to apply for asylum. Basically, with this executive order, if you are entering the U.S. in that time frame, you are going to be out of luck because you will not be allowed to apply for asylum. There's really tiny exceptions, but they're extreme circumstances exceptions. So, for example, if you were a victim of severe trafficking and you basically were not in control of your entry into the US, then that is an exception. However, if you are well within your control and entered the US, this new policy will apply to you. Basically, once the 2,500 number is reached, the number needs to come down to 1,500 before it kind of goes back to the normal processing. So it is a very big deal. It is something that's going to affect a lot of people that are entering that may have qualified for asylum, but because of when they enter the U.S. and how they enter the U.S., they are now out of luck when it comes to asylum, applying for asylum specifically. Let's talk about what you can do. So if you are outside of the US and you're trying to apply for asylum in the US, there's certain steps that you can take and not just cross the border. If you use the CBP1 app, which is basically a way for you to request an appointment with the Border Patrol and for them to screen you to see if you would qualify for asylum, right? If you have a claim for asylum. And if they find that you have a claim for asylum, they can let you into the US so that you can apply for asylum. So even though this is saying if you hit this number, you can't get asylum, however, the CBP1 app, you can still use that to schedule an appointment because that is not unauthorized entry, okay? If you have an appointment scheduled with Border Patrol, it is not considered unauthorized entry. So you really want to make sure that if you are going to do it, or if you know someone that is thinking about doing this, please use the CBP1 app so that you are not in a position that you are now out of luck in applying for asylum. Especially most of the people crossing have a basis for asylum. So you want to make sure that you're following that procedure. This is a major blow to asylum processing in the US. However, as much as I give you the issues, I want to also give you a kind of solution, and that's the CBP1 app. So the next thing I want to cover is some USCIS policy changes. So the executive order was more of a Border Patrol ICE policy change. Now let's talk about USCIS policy change, because that that typically affects most people that are trying to file for family members or citizenship, things like that. So let's cover the two main changes. So the first one is they've had a couple of changes to their policy manual. So basically, the USCIS officers have a policy manual. This is how they make decisions on cases. This is how they know, what section of the law to apply on which case. They're not in a vacuum making these decisions for themselves. There's a procedure that they're supposed to follow. There's a policy, there's a manual that they're supposed to follow. And when changes are made to this manual, they have to let us know that they made those changes. So the first one is about the people that have an I-730. So this is for someone that has asylum or refugee status, and they want to file for their family, so their spouse, their children, to also come into the US in asylum status. This used to be handled by the Asylum Vetting Center because, again, it's under asylum. So it's someone that has asylum filing for their family to also get asylum under them. So their family outside of the US to get asylum under them. And this is usually at the Asylum Vetting Center, but this is going to be changing. So they're going to be moving those cases from the Asylum Vetting Center to the International Operations Division. This is, in my opinion, this is a good thing, because the Asylum Vetting Center has now been given more work than they used to have. So the I-730s are taking way more time than they used to take, because now there's more asylum cases going through the vetting center than there was before. So before it was just the I-730 and very few asylum cases going to the vetting center. Now, a lot of the cases that are dismissed in immigration court so that the person can file with USCIS has to go through the Asylum Vetting Center. And that's a whole lot of cases going through the Asylum Vetting Center. So hopefully this will mean that we're going to get shorter processing times. Hopefully, this means we're going to get shorter processing times at the International Operations Division for the I-730s. The next change is also a change that may be a good thing, but we will need to wait and see, because all of these changes came in May of 2024. So we're going to have to wait and see how it plays out in the long run. So the next one is the VAWA applications, the I-360. Usually when you file your I-360, it goes to the Nebraska Service Center, and they immediately, without even like checking it and making sure they have everything, send it over to the Vermont Service Center. And that's where the asylum application is actually processed and intaked and made sure that everything that's needed is there. And then they issue the bona fides and everything. But here's the problem. Because it's going from the Nebraska Service Center to the Vermont Service Center, you're getting notices saying, oh, we transferred your case. And if you don't know what's going on, that this is just normal, you would think that there's something going on with your case. And this also causes cases to slow down, because by the time you take it from one service center to the next, it was taking about like a month just to get the receipt notice for some of our VAWA cases. So hopefully with this change, that's going to also affect the processing times as well. So basically, the Nebraska Service Center is not only going to get the application, they're going to intake the application. They're going to do the full intake processing, including issuing the receipt notice and all of that. So that will, at least in theory, we still have to see how it works out in practice, but in theory, this should lead to at least clients being able to get their receipt notices quicker, because their cases are actually being intaked at the Nebraska Service Center, not the Vermont one, which is just going to take more time. If you are joining me live and you are getting value out of this, please go ahead and hit the like button wherever you're watching this. I know we're live on YouTube, Facebook, and Instagram, so make sure you are liking this video. And if you have other questions, feel free to put them in the comments of this video. Even when the video ends, you can go back and put your questions in the comments. I will go back and respond to them. I always do. The last policy change is on the family-based petitions. Okay. So typically when you file an I-130 for a family member that's either in the US or outside of the US, if you file an I-130, there's a section on there that asks you if the person will be applying for a green card in the US at a USCIS field office, and they want the field office location. So they want the city and state of that field office. Or if they're going to be applying at an embassy and they would want the city and the country of the embassy. Before this policy change, if you did not select USCIS or the embassy, USCIS automatically kept your I-130. Okay, they would not send it to the National Visa Center because they don't know where you want your application to go. So it was a must that you tell them where you want your I-130 sent, either to USCIS or to the National Visa Center. Even if you put that the beneficiary, the person you're filing for, lives outside of the US, if you did not select which whether they are filing for adjustment of status in the US or for a visa at an embassy, if you did not select one of those, USCIS keeps it. If you put that they're going to be applying for adjustment of status and you also put an embassy where they will be applying for a visa, USCIS in those situations will also keep it because they don't know what you want. They weren't allowed, the officers were not allowed to guess what you want. So if you don't make it clear, they keep it. Well, that policy has changed, okay? If they look at the application, the new policy is, if they look at your application and they can tell that the beneficiary, the person you're filing for, lives outside of the US, and you did not select whether it's a field office or an embassy, or you selected both a field office and the embassy, they would send the file to the National Visa Center because the beneficiary lives outside of the US. If the beneficiary lives in the US, they will keep the application. If they choose the wrong thing, right? Let's say the beneficiary is in the US, but they actually will be applying for a visa outside of the US because they did not qualify to apply for adjustment of status in the US. USCIS will still keep those applications unless you tell them specifically you want it to go to the embassy, okay? And in those situations, if they keep it, but you want it to go to the embassy, you must file a Form I-824 to basically have them send that file to the National Visa Center. If the case is still pending, right, if they haven't made a final decision on the case, you can still reach out to USCIS and ask them to change where the case is going to be sent. So that's another good thing in this policy manual change, is that now they give you the option to contact USCIS and say, hey, by the way, I made a mistake here. I want this to be sent to the National Visa Center. And now it's up to USCIS to then follow through and send it to the National Visa Center once they approve the case. But once they have already approved the case and kept the application, you will need to file an I-824 to basically have it go back to the National Visa Center. If they sent it to the National Visa Center, right? If you wanted it to stay with USCIS, but they sent it to the National Visa Center, all you have to do is go ahead and apply for adjustment of status. Okay, you don't need to file an I-824 for them to bring the file back. No, USCIS will take care of that. They just want to know that you're applying for that adjustment of status. So that is why I always say when you're applying for your I-130, you want to make sure that you are selecting the right things. okay? Because it can really slow down your case, because we've had situations where people come to us after the fact, right? After they already filed an I-130 and the USCIS kept the I-130 and they're not sure what is going on. So we had to file the I-824, and the I-824 has a filing fee and has a processing time. So it can be anywhere. I've had an I-824 take almost a year just for them to send the file to the National Visa Center. So this is a really great change for the policy manual, but it's a great change for the people applying, because if you make this mistake, you can still get to save some time, but it is one of those mistakes that can cost you money and time. So basically, the I-130, you want to make sure everything is exactly the way you want it, or it's going to be, it can cause delays for you. So those are the updates. There was not big shifts, but these little shifts really do make a difference, because you want to make sure that you are following what is going on and how that can possibly affect your case. If you would like individual help with your immigration journey, applying for green card, citizenship, for family, for yourself, all of that good stuff, and you want to meet with me to see how I can help you with that process, guide you through the whole thing, you can schedule a strategy session with me by going to my website, lilylegal.com. When you click on contact us, you can actually pick a date and time that works best for you for us to talk. I work in all 50 states, and I have clients outside of the US as well, because there's some visas that you can apply for from outside of the US without having to be physically in the US. So we represent clients all over the world, basically. So if you would like to schedule that strategy session, you can do it by going to my website, lilylegal.com, or by calling my office at 508-443-1788. Thank you all so much for joining me, and I'll see you next time. Bye.